to driver's license, and you can't make me go and get a number just to satisfy the statute, which is written in my favor. The statute was written perfectly in my favor. I had no qualms or quarrel with the statute. And yet the General Assembly thought that somehow its whole regime was going to fall, even though I was defending the statute, and the Commissioner Green was the first one under Bredesen, under Sundquist. He was trying to force the statute in a way that it wasn't written. In other words, he was claiming an authority that the statute didn't actually give him regarding SSNs. So I pursued my case, and was probably the only newspaper editor ever to argue a case before the Tennessee Court of Appeals, in which I did in Nashville. And as that was going on, the General Assembly rewrote the law to account for my argument. My argument was that I don't have an SSN and I'm not going to go and get one just to get a driver's license. And so now the system says that if you don't have an SSN, rather, if you've never been issued an SSN, you can have a driver's license without going to get one. There's no rule saying that you have to go and get an SSN to get a driver's license in Tennessee. And that's thanks to my case. And I would say thanks to the General Assembly, right? They saw the case coming. They were needlessly worried about their statute, and so they rewrote it to account for my arguments. But now the statute is written in a way that is not adequate. And it's going to have to be challenged again by some godly man who has the same kind of confidence in God that Judge Moore has had in much of his life, and really his whole professional life as a military man, and then as a judge, and now as the Chief Justice of the High Court in Alabama. And the statute in Tennessee is going to have to be challenged because what about the man who doesn't have an SSN by virtue of rescission of contract? Mistake, error, and fraud of his father's application for an SSN on in the papers, in the record. So the General Assembly seems to have made it impossible for someone who is exercising a common law remedy, right, rescission of contract, not allowing that person to get a driver's license. Or if that person wants a driver's license, again, that's a privilege, to enter into a relationship with a privilege, for a privilege. The man who doesn't have an SSN, by virtue of that Christian conviction against against Social Security, how can he get a driver's license? The system doesn't, and they're exercised that remedy under fraud, duress, and other reasons why Social Security is in fact a fraud, a legal fraud. It's called constructive fraud. And so by their taking these remedies, often administrative in nature, they don't have an SSN. So what about a man like that? So and the state what the state will do is it will hound anybody who signs that affidavit who had rescission under one form or another. And it will do that in malice. It will do that vigorously. It will champion its virtue and hound that Christian man in the courts. And it's something that's happened before, and it's going to happen again. And so it pretends, the statute pretends that you can't have rescission. That's what it pretends to do. And since the statute was written with me in view, clearly the legislative history would show that it's intended to keep out people who are patriotic or Christian or other kinds of people who have no SSN, no Social Security number, by virtue of if we have to have a driver's license to drive, which is something in commerce, then we have to have their permission to live. Because if you don't have a driver's license, and if you cannot use the public highway, either by right or by privilege, you are being subjected to a death sentence. It is a civic or a civil death sentence. And that was my claim, was that you generally have a right to a driver's license because it is essential to life. You cannot live without using the roads. And the state wants everybody to think that they can use the roads only in commerce and only under the privilege of a driver's license, and that there is no such thing as free travel. They deny there is free travel, though for them to deny that, they have to say that the 1937 statute, which created the driver's license regime, is unconstitutional, because no statute ever violates a constitutional right. It does not do that. No statute does that. And so if the state wants to take that position, it is arguing effectively that its regime is unconstitutional, because its regime is pretending to claim the statute denied and dissolved and destroyed the right of the people to travel on the public road, which they had all through the beginning of the vehicular age, the age of the automobile, up to 1937. Right up until that point, everybody drove by right. It was a property right. The ability to move is a property right. So is the remedy of rescission. Think about it just for a second. If you have the right to own property, which you do you have the right to enter into a contract? Yes, you do. A contract that has consideration, meeting of the minds, and other things which are definitions of contract. Well, if you have a right to contract property for property, to enter into an agreement, do you have a right to void or nullify or rescind that contract? Yes, you do. You have that right if the offense that is part of that relationship, if the offense is sufficiently identified and the relationship is properly dissolved, and that's called rescission of contract. To rescind, right? To undo something. It is a remedy. It is a property right to rescind something, whether for fraud or mistake or duress or anything else. Contracts have to be entered into freely and honestly and honorably. And if you can find fraud in a contractual arrangement that you're being defrauded, you simply have to find the remedy, and it's called rescission. RESCISSION, rescission of contract. It's a very important remedy. And people who understand the federal system to be fraudulent in many, many ways, to be so much BS, they often resort to that remedy. I've met people who've done that. And in fact, I was involved in that myself back in the late 90s, seeking to be as much a free person as I could be, without the entanglements of the state, without the obligations of the state upon me, without the promise of rescue, right, of the state, which is the great promise of the political promise of Social Security. It is a promise of salvation in your old age. You will be guaranteed an income. You will be saved from your needs and your wants, and your lacks will be cared. You'll be cared for by the state. It's not a legal promise. It's not a contractually enforceable promise. It is a political promise only. And yet, it's the whole Social Security system is presented as if it were insurance. It's not insurance at all. It simply is a political promise that's easily changeable and can easily be rescinded. Right, the Congress can rescind its promise to the American people. And overturn Social Security or refuse to fund it. And what recourse have you? Well, you have none. You have no recourse at all. And I'm getting a phone call here, and I was going to get to something about Judge Moore, but your call matters to me. This is David Tulis, and you are live on the air at AM 1240 Hot News Talk Radio. What's on your mind?
Three things. First of all, Judge Moore is setting the example for everyone. And I'm going to give you my first example is when I was charged with having dogs without licenses, and the 20 people before me pled guilty, and the judge fined them. And I said, I want an evidentiary hearing, where's your probable cause, on and on and on. And the judge looked at the prosecutor and said, if you come on my property, you better have a search warrant dismissed. So the judge was looking for a patriot to stand up and make the case. They can't make the case for you. Judge Moore is setting an example, people. Look at him. He's the highest court official in that state. Come on. Second thing is you hit a hot button. There is no Social Security money. There are no Social Security monies set aside. The Supreme Court ruled the idea that government can take care of you is unconstitutional. That's never been changed. It's the 1930s rule it. Social Security is a lie. Even the name is a lie. It is collected as another federal tax. It is an income tax, which the employer and the employee, the master servants, both pay to the federal government. And when you're of a particular age, or if you're disabled, you get to apply as the welfare recipient of the state, the sheep, the gnome, the minion of the state, for the benefits of mommy and daddy or the government. But there are no Social Security funds. There is no insurance policy. It's illegal and unconstitutional. Another government lie. And the third thing, you have an absolute individual constitutional common law right to take your motor vehicle on the highways of any state and travel from point A to point B as long as it's not in commerce with no permission from the state. I did it in 1980. no driver's license, no registration, no insurance, junk title, got pulled over and won. Now you have to make the commitment to fight every jurisdiction on this. But the point is, David, you're telling the truth. And when people hear this, they go, oh, it's not the truth. And they have to look in the mirror and realize, now I know the truth. What am I going to do with it? I'm going to, you know what they're going to do with it? They're going to do nothing. Because they love being controlled, and they love the big fat police state, and they love the welfare system.
Well, I think you're
explodes, do nothing.
I think you're mischaracterizing the people. I think the people don't love what they have. They just sort of dread it and accept it. I don't think my listener or people he knows love the police state, love the surveillance state, the tax state. I think though they feel that there's nothing they can do to stop it. All they can do is comply. Because the costs of challenging it are too high. The time costs involved in even thinking about it are too high. They're oppressed they've got 2 jobs. The wife has a job. The children are in school and have problems at home. People don't have time.
Let me tell you why I don't buy it. Voters are criminals, first of all. Whoever votes is a criminal. When this country was founded, you couldn't vote for anyone to steal your substance to control your life. Now, evidently, people think they can vote for someone to steal something from someone else or do something for them. Therefore, I believe voters are criminals by proxy. And that means the politicians, pass laws and the police enforce them, and the sheriff, whomever, maybe the IRS. So voters, in essence, are criminals. If they weren't criminals, they would elect people to take away laws. A lawmaker, if we're free, what do you do with laws? Why do we have lawmakers? You should have law unmakers. So voters are criminals. Every single person that votes is a criminal.
Okay, I don't think that's true. People are innocently voting for parties, and they think there's resolution. They're being misled. I don't think they're criminals, which implies intent to wrong other people. They are simply misled. And voters they want people who say, well, you didn't vote. Who are you to complain? The rebuttal, I think, of our caller would be, you're a voter. Who are you to complain, right? He kind of turns it on his head. Well, Judge Moore is a constitutionalist, and in his book, So Help Me God, he has a couple of great quotes. He says, the Constitution itself has not changed in these areas. He's talking about important moral areas, touching on marriage, for example. But the ideology of the Supreme Court and lower courts certainly has, because we have exalted the Supreme Court as the gatekeeper of our laws. Our fundamental law has changed with them, he says. I don't know that I would make that concession, but he says, consequently, there is no permanence to our law. The Supreme Court and lower federal courts make decisions based on their feelings rather than the words of the Constitution, defying the meaning of the rule of law and making judicial decisions nearly impossible to predict. Right? You have Windsor, then you have Obergefell. Some people have forgotten the vital point that judges' decisions are opinions about the law and not the law itself. A person's opinion on a particular topic carries weight only if it's supported by the facts. Likewise, the opinion or rulings of a court deserve obedience only if they are supported by the law. He says, a court decision not grounded in the Constitution does not merit the respect we owe to the law itself. Such a decision is nothing more than a judge's opinion based on a whim, not on the law that we, the people, agreed to be governed by as a nation. What are the consequences when state officials, such as my fellow justices on the Alabama Supreme Court, obey a federal court order that is not consistent with the Constitution? This is a book about the monuments case. It's his biography touching on his fight for the monument. First, by assenting to a ruling that is not based on a plain reading of the constitutional text, the state official agrees that it is the federal courts and not the Constitution and the laws that govern the country. While this may be the practical reality in many areas of law today, just because it is happening does not mean it is right. If this point is surrendered, then we have no Constitution, no fundamental law, and no fixed authority to appeal to when those judges make mistakes. Judges, like everyone else, make mistakes. Without a standard to which judges are held accountable for their mistakes, our rights are at their mercy. And he says obedience to such a ruling means that the state official has violated his oath to support what? The Constitution. An oath is a solemn promise before God and the people whom the official serves. Violating such a promise is not something that should be taken lightly. And when I read that this morning, I thought, what about Bill Knowles, our county clerk? What about his oath of office? Did he take his oath to support the Tennessee Constitution and the marriage amendment lightly? Indeed, if the state official is willing to violate such a solemn promise for the sake of avoiding conflict with federal authorities, we have to wonder if he can be trusted on any other issue. In other words, if the state official or the local official yields on the point that matters the most, which is the Constitution itself, the integrity, say, of marriage, the fount of capital, the basis of capitalism and the free markets and human society, if he rejects defending marriage, how can we trust him with beer licenses and tax receipts? You have to wonder. This is David Tulis.
You give us 12 minutes and 40 seconds, we'll give you Chattanooga and the world.